This is Mr. Nevis.
All right, Mr. Nevis, raise your right hand. Do you swear or affirm the testimony that you're about to give us the truth, the whole truth, and nothing but the truth, so help you God? Yes. Go ahead, the seat up to the stand.
Can I begin now?
Yes.
Please state your full name.
William Lee Needs III.
Mr. Nevis, do you know Delinord Dumercy?
Yes.
Okay, how do you know him?
We were co-workers and friends.
And how long, when were you co-workers?
A couple years ago, Schulerberger.
Were you his manager?
Yeah. I was back of house kitchen manager.
Did there come a time that Dumercy lived with you at your home?
Yeah, for basically the whole month in November.
And did he, what year?
3 years ago, so not off the top of my head, I'm sorry.
I'm sorry?
2016, I guess.
Well, you guess or what?
It's 3 years ago. Off the top of my head, I'm not sure.
I guess the 3 years would be 2016.
Yeah.
And you're aware that, obviously, you were aware of the shooting in this case, is that correct?
Yeah.
So it was the year that the shooting occurred?
Yeah.
Okay, so, first of all, did Delinord Dumercy ever tell you he was being threatened?
Yeah. In the months coming up to that.
And did he ever tell you that he had been shot at?
Yes.
And tell the court, did he do that by phone or in person, or how did he tell you?
He had called me on the phone shortly after it happened.
And what did he tell you?
Well, I'd already known that he'd had problems with the person for a while, and he had said that he had multiple threats. And at one point, he was on his way home or was on his way to a store or something like that, and somebody had drove by and attempted to shoot at him. And he didn't get a great look at exactly what was going on, but he knew that he'd already had somebody in mind that had been consistently threatening him.
And did he tell you why he was staying at your house?
He had been staying at my house to kind of be in a different spot as far as, because it was easier to not be known where he was.
And did there come a time that he quit working at your location?
Yeah, he just quit. It was something to do with having a phone call, somebody threatening that they knew where he was.
And did he tell you about that phone call?
He had told me about it, yeah.
Okay, that would end the property, right?
I'm sorry?
That would end the property. That's all we have to testify to.
All right. So, Mr. Farfield, do you want to cross-examine or do you want to just have argument?
I think it's just argument.
Okay.
Okay, so let me tell you, the court, what my point is for putting this on. One is...
Hold on a minute. Let me look
out
for the news. Go back.
You go outside, Mr. Nevis. You can't talk about anything that took place because you're a witness in the case.
The bulk of what Mr. Neves would testify to is hearsay. It's statements. He's testifying to statements made by the defendant to him. He has no personal knowledge of any of the difficulties between the defendant and anyone else. He's testifying to phone calls and other statements made by the defendant, and it's being offered to prove that these things took place. It is classical hearsay, and those portions should be inadmissible. I think it is admissible that he was the defendant's manager, Schulerberger, that the defendant lived with him for a period of time in November 2016, and that the defendant quit Schulerberger. But as for the specific reasons why, it's all based on hearsay, self-serving hearsay of the defendant. This testimony was also attempted to be offered during the standard ground hearing, and it was excluded then, and of course continued to exclude.
And just this is why it's imperative for us to get this in.
Well, just tell me how it comes in under the hearsay rule.
Because this state, through the detectives, have already attacked the credibility of Mr. Dumercy's statement regarding self-defense, basically saying that he fabricated that, when he came in to speak with law enforcement. We have a right to show that well in advance of the shooting, And prior to ever speaking with law enforcement, he disclosed to people the same exact facts of threats and the shooting in this case that he disclosed to the officer during his interview. If the court didn't allow, let's say the court doesn't allow that, I would prohibit the state from attacking the story. I would ask the court that you prohibit the state from attacking what he told the detectives. Whether it be on cross-examination of him or in closing, because...
Hello?
Because if the state gets out there and says he's just making the self-defense up, well, actually he's not, because he told numerous people, which are the other witnesses, about these threats and the fact that he had been shot at, well in advance of this.
Well, I certainly understand your reasons for wanting this in, but tell me how you believe legally it can come in.
Because it comes in legally.
What's the exception to the hearsay rule?
Well, it's not hearsay, it's coming into as a prior consistent statement, as showing that it was not a fabricated statement at the time he met with law enforcement.
Mr. Parkfield?
Your Honor, if the defendant, when he testifies, can be asked if he told the story to anyone else.
Well, I think clearly the defendant would have to testify, Mr. Dumercy would have to testify to have this come in as a prior consistent statement.
Yes, and I'm saying if that is then attacked, that testimony is attacked,
Right.
then they could introduce
Right.
extrinsic evidence. But at this point, it's in other words, they couldn't call this witness first before there's any other testimony.
Oh, no, I don't think he's calling this witness first. I think he's just doing it for the proffer now. But it sounds to me like you're going to call Mr. Dumercy, subject him to cross-examination, and if he is, let me just see the... Yes, go ahead.
Well, I was thinking about this morning, is that if I did not call him, the statement is in evidence that he gave regarding stuff. He is going to testify, but if I chose not to call him, or if he chose not to testify, but he did give a statement that the state entered into evidence,
The
so...
rule is that he has to testify. A statement is not hearsay if the declarant testifies at the hearing or trial, and he is subject to cross-examination concerning the statement, and the statement is inconsistent, well, that's not the one, consistent with the declarant's testimony as offered to rebut or express or implied charge against the declarant or improper influence, motive, or recent fabrication.
Well, I did plan on putting him on the first.
Well, that's what I figured. Okay.
But I think if there's any indication from the state, like attacking a self-defense issue, or what he told law enforcement, I believe this would be admissible.
Well, that's once he testifies.
Right.
Well, that may be true. I mean, I don't know what the cost is going to be, but I guess we'll just have to wait and see.
But that is what he would say.
Okay.
If it turns out, we'll readdress it obviously.
Okay.
Before, if it turns out that the court rules he cannot take the stand and testify to that, I'd probably still call him just to confirm that he lived there, worked there, and that he had left.
Okay.
To confirm the time period.
Okay. Well, that would certainly be permissible.
Okay. So I guess let's see what happens with the
Okay.
prosecutor.
All right. Now, did you have another witness?
I do. I have two more that are going to say.
Okay, I think what I'm going to do, because I've kept this jury out way too long, is wait until the state rests, because we have to take a recess then, and then maybe we could do it then. Okay. All right, so let's bring the jury in.
I'll go get the witness.
Yeah, well, let's get the detective first.
I'll get it.
All right.
Thank you, ladies and gentlemen. Please be seated. When we left off yesterday, Mr. Fleischman was still doing cross-examination, and that's where we're going to pick up this next. So, Mr. Fleischman.
Good morning.
Good morning.
I think when I left off, we were talking about the the phone, so I want to follow up on that a little. Were you aware that Mr. Peoples had an iPad that he texted and potentially called on?
I was unaware.
Did you ever ask Ms. McRae how she communicated with Mr. Peoples?
No.
So it's fair to say that, although redundant, I do want to ask you, on the iPad, right, you never collected any type of iPad, any communications device belonging to Mr. Peoples, is that correct?
Yes.
And is it fair to say that Ms. McRae never volunteered that information to you?
Yes.
Okay, I believe, got one moment, but maybe I'll have. Actually, I'm sorry, one other question. Did you search Ms. McRae's vehicle the night of the shooting?
No.
Did you direct crime scene or anyone to search the vehicle?
No.
Okay, that's all I have. Thank you.
Thank you, Director. All right, thank you very much.
Gonna just send a state rest.
All right. State will arrest this case. Ladies and gentlemen, I just have to ask you to step out again for a few minutes, if you would, please. While you're out there again, please don't discuss this case amongst yourselves. Don't use your cell phones to look up anything about the case. Don't do any research about the case on your cell phones or in other electronic devices if you have any. And we'll see you in a little bit. Thank you very much. What?
So to the close of the state's case, first I want to renew our stand your ground motion. I'm asking the court to consider the facts as they came out during the course of the state's case and find that Mr. Dumercy had a lawful right under Florida law to stand his ground and therefore grant him immunity, which in essence would dismiss the case. So that would be my first request. My second request is the court grant judgment of acquittal. The state has not proved a prima facie case of first-degree murder, which is what Mr. Dumercy has been indicted for. There's no evidence of premeditation, and we're asking the court to find that taking into account what really is evidence, even in the state's case, of self-defense. The fact that Dumercy went in, immediately told them he was acting self-defense at the time of the shooting, that there were prior threats. Now, there's really been nothing to rebut that.
When you say immediately went in, you mean the next day?
Yeah, the next day.
But right at the time?
Well, it was close, pretty immediate.
Okay.
The next day. The fact that he disclosed to them that he was acting self-defense, there's really nothing to rebut that. There are text messages, but the text messages themselves don't rebut the self-defense issue. And I also would ask the court to take into account that the missing text of Ms. McRae that said, James already wants to kill you. Clearly, that was not in her phone, and it's likely, I believe it would be a fair argument to the court that she probably destroyed that text, before she turned over the phone to law enforcement, because that had nothing to do with the dump. But they still had access to her phone, so they were able to confirm that text was actually missing from, her phone. They weren't able to do a dump to see if it was actually destroyed or not, but I think it's a fair argument that she dispensed with that text, probably purposely when she turned the phone in.
That's the text that she said she sent to Mr. Dumercy.
Well, the text that she admits she sent that thing.
She admits that she sent that to him.
Right, but only now. In other words, she never turned it over to law enforcement.
And what am I supposed to take from that?
Well, I think it goes to her credibility as to, her testimony as a whole. The fact that it looks like she destroyed what she believed to be a text that, may have been harmful to Mr. Peoples' position. There's a history of threats that Mr. Dumercy testified through his statement, which is in evidence to the police, that he was shot at. Again, there's no evidence of premeditation, at least not sufficient for beyond a reasonable doubt or a prima facie case. So we're asking the court to grant judgment of acquittal as to the indictment of first-degree murder.
Okay.
The state has a proven prima facie case.
Well, in moving for a judgment of acquittal, the defendant admits not only the facts that were stated in the evidence, but also every reasonable conclusion favorable to the state that the fact finder here, the jury, might fairly infer from the evidence. So based on the evidence that was introduced and viewed in the light most favorable to the state has established a prima facie case of guilt in the court's opinion. So accordingly, the motion for judgment of acquittal is going to be denied.
But we also do want to re-raise when Detective Hart testified, he said, which was objected to, that the officers or police make a decision whether a crime occurred, immediately objected, moved for mistrial. The court did give a curative instruction, denied the motion for mistrial. I am, however, re-raising to preserve the issue, the motion for mistrial this time. I'm also moving for mistrial not being well, I'll hold off on, I want to see what happens with defense witnesses.
Okay.
How far I need to go to preserve. I may not have to.
It's okay. All right, so you're ready to put on testimony?
Get the Creole interpreters here. Did you want to take those, the properties
Okay,
first?
let's do that.
Do you want me to use the CD, or you want to just use what's on my computer?
What's on your computer, because the other person got
Did you want me to swear him down?
Yes.
Okay. Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Yes.
Est-ce que vous attendez me plaît?
Go ahead.
Est-ce que vous attendez me? Oui. I'm ready, Your Honor.
Thank you. Please state your full name.
Dis tout nom du dossier.
Rosmelia Tassi.
Rosmelia Tassi.
And how do you know Delinord
Comment
Dumercy?
fait connaître Delinord Dumercy?
C'est le premier petit garçon, moi.
He's my first child.
And where do you live, Ms. Tassi?
Et qui va arrêter Madame Tassi?
C'était 319 Nord-10, 3e avenue Delray Beach.
I live at 319 Northeast, 3rd Avenue, Delray Beach.
I want to ask you about an incident that occurred at your home.
Okay.
Did there come a time that someone came to your home and asked for Delinord in December of 2016?
En décembre 2016 là?
Oui, en décembre 2016.
Yes, December 2016.
And you are familiar with the shooting in this
Est-ce que
case?
vous connaissez en affaire de tirer que vous avez tiré dans le casa?
Non.
No.
Well, you know that your son is
Mais
charged
vous
with
connaissez que petit toi il a accusé.
a shooting in this
Accusé,
case.
il dit c'est lui-même qui tiré dans le casa.
Oui.
Yes.
Okay, so do you remember how soon
Est-ce que
before the
vous
shooting
songez combien de
that
temps
the incident I'm going to ask you about
il a
occurred?
tiré que incident ça et la caillou t'est fait là?
Une semaine avant ça.
A week before that.
And can you tell the court what
Est-ce qu'on a
happened?
dit tribunal là qui ça t'est passé?
So, dans le travail, dans le matin,
So I went to work in the morning.
les bin au travail,
When I came from work,
Et puis, je suis dans le salon, je prié, je dit bon Dieu merci.
And I sat in the living room and I was praying, telling God, thank you.
Parce que il fait passer journée en bien.
Because I spent the afternoon well.
So, pendant ma prière, je dans des portes la frapper.
So while I was praying, I heard a knock at the door.
Et puis, je m'entends, je sautais.
And I was shocked.
Parce que là, ma prière, je toujours dit timonio, pas moyen, pas relais.
Because when I'm praying, I always tell the children not to interrupt me.
So,
The interpreter stands corrected, not to call me.
And did you go to the front door?
Et est-ce que tu allé dans la porte devant?
oui.
Yes.
Tell the interpreter, can you tell Mr. Dumercy, let me ask the question? Yeah, let me ask the question first. and that's what we do next.
Qui te demande des questions avant, et puis après, on va avoir réponse. Okay?
Did you go to the front door?
Est-ce que tu es allé dans la porte devant?
Oui, premièrement, je allais dans la fenêtre là.
Yes, at first I went to the window.
And who did you see, if anyone, out the window?
Et qui est-ce que tu es là, tu es campé dans la fenêtre?
Moi, son monde qui gagne dread.
I saw someone with dreads.
And what happened next?
Et puis, qui s'est passé après ça?
Et puis, so, je pense, parce que je connais pas des amis qui gagnent toujours pas les témoignages.
Well, I was thinking, because I know I don't have any friends, and I always tell my children
Et je pas aimer pour faire des amis avec des gens qui gagnent cheveux tressés parce que
that I don't want them to make friends with anyone that has their hair braided because...
All right, well, let me tell her, this is my question. What
mes questions.
happened next?
Qui s'est passé après ça?
After she looked out the
Après,
window?
où t'es regardé, ou regardé dans le vide là?
l'aime garder dans vite là moi c'est cheveux tressés et puis je prie me dit Seigneur moi ouvrir porte là même gon.
Well, when I looked out the window and I saw the guy with the braided hair, I said, God, I'm going to go ahead and open this door.
Et puis m'ouvrir porte là.
And then I opened the door.
What happened
Et
next?
qui s'est passé après ça?
Il dit hi et puis me dit hi.
He said hi, and then I said hi.
What happened next?
Et qui s'est passé après ça?
Il dit maman côté Delinord.
He said, Mom, where is Delinor?
Il dit Delinord pas arrêter là encore.
I said that Delinor does not stay here any longer.
What happened next?
Et qui s'est passé après ça?
Il m'a demandé une deuxième fois côté Delinord.
And he asked me a second time, where is Delinor?
Il dit comme ça ou connais amour va arrêter là encore parce que me connais ses amis Delinord hier.
I said to him, you know that your friend doesn't live here anymore, because I knew that he was Delinor's friend.
What happened next?
Qui s'est
So-
passé après ça?
Il dit comme ça ou chaud maman est-ce que Delinord va lever là encore.
So he said to me, are you sure that Delinor does not live here any longer?
Et puis il virait Jean le virait moi elle fâché et puis
And the way he turned and left, I saw that he was upset. And then
moi le mari moi et puis me dit ou connais gon monde là qui demander pour Delinord.
I called my husband and I told him that, you know, that somebody came here asking for Delinor.
L'aime dit Delinord pas là moi elle virait Jean le virait elle fâché.
When I told him that Delinor was not here, and when he turned to leave, I noticed that he was upset.
So me dit
Let me ask this. Did you contact Delinord?
Est-ce que tu as contacté Delinor?
I called Delinord. I said Delinord.
Now tell her she has, I want her to speak to the
Faut
interpreter.
parler en créole pour interpréter la qualité.
Moi le Delinord. Me dit Delinord.
I called Delinor and I told Delinor
Moi on s'est cheveux dread vinn demander pour
that I saw someone with dreads that came to ask for you.
tant pis. Dis pas vinn la caille moi encore.
Please tell him not to come to my home anymore.
And now, did there come a time that you
Est-ce
learned
que tu as que tu
who that
apprendre
person was?
qui est moun sa te?
So l'aime vini connaît qui mon nié
So when I found out who he was,
Well, my question is, when did you find out
question
who
mwen
it
ke
was?
ki le ou te vin konen ki es moun sa te.
Se le fin mouri mwen ki moun.
It's after he died, that's when I knew who it was.
And how did you find out who it
Donc ki
was?
jan te fin fè vin konen ki es.
Se lè sa te fin pase ya, so premier jou am pat bon.
After that happened, the first day I was not well.
Deuxième jou am pat wel nte l'hôpital.
After,
The
hold
second,
on.
etale.
After what happened?
Apre ki
So-
sak te pase ya.
Apre 3 jou mdi ti moun yo tanpri.
After 3 days, I told the children, please,
But my question is, after
question
what
nan,
happened?
se apre ki sak te pase ya.
Apre shooting na fin fet,
After the shooting occurred,
Okay.
mdi ti moun yo mvin repran mwen apre 3 jou.
I came to my senses after 3 days,
Mdi ti moun yo montre moun nan.
and I told my children, show me the person.
So yo chache sou internet la,
So they looked on the internet,
yo montre mle.
and they showed me him.
Lè sa mpe ton rel kriye,
That's when I started crying.
lè map kriye ti moun yo mande mte vle pedi kontrol ankon, ti moun yo mande sak pase maman.
When I was crying, I almost lost control, and my children were asking me, what's wrong, Mom? What's wrong?
Mdi se men moun sa mte wè, jou ki te vin fwape pot la, ki te vin mande pou Delinord.
I told them that's that same person that I saw that came and knocked at the door that asked for Delinord.
And that's how you found out who the
Et c'est
person
là ça
was?
où t'es venu découvrir qui est moun sa te?
Oui.
Yes.
Okay. That's all I have.
OK? C'est celle question ça qui me dit juge.
No problem, sir.
OK? Bah, l'autre question.
And the purpose for this proffer is,
Did you want to sit in front of the witness?
well,
I mean, we can approach if you want. Just-
no, I mean, we don't need to have any more questions for this, right? That's,
Yeah.
so.
On va regarder la question aussi.
Remain outside for the time being.
OK, il met le chita dehors. Pour juste en finir.
Okay, Mr. Frontier.
Your Honor, as set forth in the state's motion in limine, as the court knows, the specific act evidence in a self-defense case of the victim is only admissible if the defendant has prior knowledge of the specific acts. Based on her proffer, the linkage between the individual that came to her home and it being the victim was not made by Mr. Dumercy's mother until 3 days after the incident. I would say that if she could testify to the incident itself, but not to the subsequent identification of that as the person. So she could testify that someone with dreadlocks came to the door, asked twice for her son, and then left. But as far as going further to say that it was the victim, I would say that goes into specific bad acts of the victim, and the defendant did not have information of that. The defendant was only informed that a person with dreadlocks came to the house and then left.
Actually, I agree with the state on that. That's not why I'm bringing this in. I'm bringing it in against show when Dumercy testifies, he's going to say that he had gotten a call from his mom that, someone with dreadlocks had come to the home. That's one of the incidents that created fear in him because he believed that, it was, Mr. Peoples. And then as it turned out, his mom found out after the shooting that it was Mr. Peoples. Right, so I planned on putting her on again to substantiate the fact that he did not make this up. Because he even told the
As
detective.
far as her testimony about the identification by showing her 3 days afterwards who it was.
Well, it would only come in if I believe the state attacks his credibility of, if he gets up there and they're opine or make it appear to the jury that he's just making that up, that he received a call from his mom.
Right, but he received a call from his mom that somebody with dreadlocks was at the door asking for him. And when they found out he wasn't there, according to the mother, they appeared upset in some way and left. But why do you think it would be admissible that 3 days after the shooting, her children, I'm not sure which children, showed her a picture of the decedent, and she then began to cry for some reason and said, oh, that's the man who came to the door? How is that admissible?
Well, I believe it's admissible to show that it actually was Mr. Peoples, and it's
The
consistent with...
defendant, Mr. Dumercy, didn't know that at the time of the shooting.
Well, he believed that it was Peoples that came to the house.
Right, well, he may have believed that for some other reason, but, I mean, in effect, what you're doing is bringing in something that would otherwise be, I guess, a prior bad act of the victim that he didn't know about at the time, because he didn't know who the person was, because nobody told him who it was. He found out after the shooting, so that, I mean, that would have no bearing on his knowledge prior to the time of the shooting. So I'm just saying, certainly what she says, other than 3 days after the shooting, we learned that was the same person, because that would be irrelevant. Everything before that would be fine.
Okay, well, I'm sticking with, I believe it would be relevant to show that it actually was Peoples that came to the house, and that it's consistent with Mr. Dumercy's fear that he was looking for him and knew where
But he
lived.
didn't know that at the time.
Well, he knew it enough, he had enough information based on what was going on, the fact that this person appeared at the house.
Well, you can certainly argue that, but for you to then bring in something 3 days after the shooting is the first time you learned who it was. I mean, you could certainly say, well, okay, the guy had dreadlocks, he was an African-American, maybe you can get out his size from the mother, but, you know, he didn't know who it was. He may have thought, oh, that's probably who it was. But for him to later confirm who it was, that would not be relevant.
Okay, I mean, our position is, it is.
I understand,
That's your-
I understand.
Okay, so I guess I need a secondary ruling. Is she allowed to just testify just cold? In other words, after Dumercy testifies regardless of cross-examination? Or do you need to wait and see what happens in cross-examination? Like with Nevis? Yeah, in other words, I mean...
To all those things that I told you I think would be okay, yes, you can testify to that.
Okay, what about Nevis, though? Are you allowing
Nevis?
Nevis and Mr. Nevis?
Well, Mr. Crumfield, as far as Mr. Meaves is concerned?
Mr. Meaves, I thought the court's ruling was that Mr. Meaves could testify about Delinord's, or Mr. Dumercy's living situation, his work situation, but that he would not be able to admit the hearsay unless Mr. Dumercy was cross-examined about fabricating his statement to the police.
That's what I usually do, so
Okay.
we have to kind of wait for Mr. Dumercy.
But just so we're clear, the state is obviously intending on confronting Mr. Dumercy about statements that he made to law enforcement at the time that he made them. And the state's position is that a prior consistent statement is only if there's a allegation that there's a recent fabrication of the statement. Then you could use a prior statement that arose before that necessity to make the statement in place. So the state's position is not that just by simply confronting Mr. Dumercy about what he did or did not tell law enforcement, it doesn't just automatically open the door to all these other prior statements that were made by him, as long as it's not to combat that there's a recent fabrication.
Well, Judge, I disagree.
Well,
I think there's
let
any...
me say, I mean, I think that what he's going to testify to is that he moved, I guess, several times because he was in fear for his safety, and he's, I guess, told Mr. Meaves about a shooting.
The threats.
Right. And, you know, I think if he testifies and he talks about something that he's
previously told somebody else, I mean, I don't know why that wouldn't come in as a prior consistent statement. Can you tell me why it would not?
Because the prior consistent statement would be to rebut a express or implied argument that it is a fabrication.
Right.
If the argument is that the defendant's in-court testimony is biased, or in other words, some of the things that he indicates later were part of his decision to be in reasonable fear and they were not brought out to law enforcement at the original time, that doesn't mean that we're saying that that statement is fabricated, just that it is not a truthful statement. You could tell a lie before you have that specific time to tell the lie.
Not sure about it.
For example, Dumercy's version of the events to law enforcement is, I was in fear.
So you're saying his original statement was a lie?
Dumercy's version of Dumercy leaves out the fact that he has been texting and threatening this whole time. So to cross-examine him, you didn't tell the police about any of the statements that you had made to Ms. McRae. In fact, you never told the police about the statement that Ms. McRae said James wanted to kill you. You never said that to the police. That's not arguing. It's arguing bias. It's not saying that he's fabricated his statement. I mean, that could be how Mr. Dumercy perceived the events, because he's always told his biased version of the events.
Respectfully, I disagree. I believe if there's any insinuation that his statement to law enforcement is untruthful or fabricated, to use that term, we're allowed to bring in prior consistent statement. There's a body of case law overwhelmingly in favor of that. I mean, how would that not come in? If there's even insinuation that he's fabricating the statement to law enforcement, that's the whole point under the rule.
I think it comes in, so, depending on your cross, and, I guess we'll have to wait, but I'm pretty sure you're probably going to seek to impeach him on his statement, but again, I guess we'll have to wait and see. And did you say you have another witness?
I do. One other one, Pastor Jackson. I don't need an interpreter for him.
All right.
His is extremely short.
His is just that he was living with him at the time?
Living with him, and that he was afraid, his demeanor was such that he appeared afraid to leave the house. He was living with him just prior to the, actually he was living with him at the date of the shooting.
And are these addresses where he lived with Mr. Neves and the pastor all addresses that he are shown on like all those text messages?
Yeah, those were vacant homes.
Oh,
Yeah, he testified. Those were just vacant lots.
All right.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full name.
Jackson Destin.
And how are you employed? And what type of work do you do?
I'm a pastor of a church.
And do you know Delinord Dumercy?
Yes, for about 7 years.
Did there come a time that he lived with you?
About the time when the incident happened, like probably like 3 to 4 days earlier.
Prior to the shooting?
Yes.
And who else was in your home at the time?
My wife and my kids.
You have younger kids or older?
From 17 to 6 years old. I got 4 kids.
And how would you describe Mr. Dumercy's demeanor while he lived with you?
At that moment, because like my wife called me and said like he
But you
came.
can't get into what someone else told you, but what did you observe yourself?
Okay, repeat the question.
And how would you describe his demeanor that you observed while living in your home?
He was acting weird, like he was scared.
And what do you base that on?
Usually when he came over, usually like outside the yard, like if the other kids are playing, but for the period of the time, he always like indoors mostly.
Judge, could I have one moment?
Yes.
Okay, that's all. That would be it.
Do you want to cross again?
Just briefly, Your Honor.
Okay.
Pastor, was the only reason that you believe the defendant was scared because he was indoors when he was at your house?
Yes.
There was nothing else that made you think he was scared?
He didn't talk to me. He didn't like approach me to tell me what was going on in his mind.
Okay,
So-
so all you observed was that he was indoors whenever you were at your house?
Yes, and also like when like for example, if the door, like if someone knock on the door to come inside, he's like if he was at the living room, he went back to the room right away. It's like hiding for something for someone I don't know. But I didn't ask him or anything. I didn't say anything to him. I was waiting to see if he's gonna come to me. He didn't say anything to me.
Okay, so he would be indoors, and if someone knocked on the door, he would go in his room?
Yes,
I have no further questions.
thank you.
Let me just ask, did you know if he had a firearm on him?
No.
Any other questions, Mr. Fox?
Yeah, that's it.
Okay. All right. Thank you very much, sir.
Thank you.
Judge, can I just tell all the witnesses that they have to remain outside? I just want to make
And then we're
sure.
going to bring you to
They're all, they're there.
Can I ask the deputy to tell them just to remain outside?
And Your Honor, as for the pastor, we would object to him giving the opinion that the defendant was acting scared. Based on him being inside and him going to the room whenever someone came to the door, I would have no objection to him testifying to those facts.
Just because we're making the objection now, Mr. Fleischman, I don't think he has provided sufficient testimony to be able to give an opinion about scare just because the defendant is staying inside the house. He can certainly say he was always inside the house rather than going outside, but for him to say he's scared, I don't think that's coming.
Judge, let me just opine on that. But it does not require an expert witness for demeanor. You know, that's like even in a DUI case, you know, a person can say, well, the person looked intoxicated. I would say this is no different. In his opinion, he looked scared based on his observation that he remained in the home and that when someone comes to the door, he
Well,
ran.
that's the only reason. I mean, it wasn't anything about facial features or conduct other than he was just always in the house when I was home. That in no way shows that somebody is scared. I mean, it's got to be a little bit more than that. So for him to opine that he was scared simply because he saw him inside of the house and not outside the house, that's not coming in as an opinion. You would have to have more than that as far as
Well, I'm not going to make anything up. That's what his testimony is.
well, why would you want to do that?
No, I'm just saying, you know, like I don't want to call him back in. So that's
Well, I mean, he was asked on cross, is that the only reason that you thought he was scared? He says, yes, because he was just inside the house.
That's just testimony.
Right.
So I'm just going to rely on that. You have our position. We believe that would be sufficient.
Okay,
And
I'm
then,
telling you beforehand, you know, I'm not sure how you might try to ask the question, but please do not say, did he appear scared?
no, well, I wouldn't get into, I mean, you wrote him out. So the only reason I would call him would be,
No, that's fine.
Like the dates is in the
Show
house.
you know, certainly. And you could certainly ask him, you know, did he stay inside the house? Did he go outside the house? You know, what did he do while he was at your house? He might say, well, he stayed in the house the whole time, which may arguably give you exactly what you want anyway. I mean.
Well, can I ask him what would happen if someone knocked on the door or came to the front door?
Well, that kind of calls for speculation. I'm not sure.
No, if he saw it. Yeah, because he said when someone came to the front door, he would go to his room.
Well, I didn't hear that come out. Did he say
At
that?
the very end.
No, I didn't hear that. Okay. Well, I mean, he can certainly say what he observed. Okay.
So that's all our witnesses. Yes.
I'm just hopeful that we can finish the case before it gets too late today, and maybe, I don't know, any closings today? I'm hopeful. Okay.
You know, before, I got to get the video set up.
Why don't you go ahead and start?